Okay, the next question, I think, goes to Helen. And this is the first question that is from someone in the audience.
Can you speak up a bit?
Oh, sure. Oh, I can speak up really, really loud. I didn't think anybody really wanted to hear me. What can be done about limiting extensions if a child has been in foster care before?
Well, I think I just addressed that. Tell me if I'm wrong, but I think that narrowing it down to children's services being the ones to request the extension will have a huge impact, because children's services is overburdened. They have children with high needs, high mental health needs, high substance abuse needs. If that child can instead be placed, that is probably what children's services is going to want.
Does the 24-month clock restart?
You mean if a child comes back into
Yes.
care? Yes. So if a child was placed and then something happened with that placement, say that placement, the custodian died and children's services had to come back in, yes, that clock would restart. But we don't see that a whole lot.
Chad?
Yeah, I think what we need to do in this particular case is make sure everyone's following. There's a lot of different tools that can be used. One, Children's Services can file a motion for a bypass, and basically where they don't have to show that they needed to show services to this family because they've been back in our system multiple times. With regards to the coming back, the clock doesn't necessarily always restart, because what happens is if the child is out of care for 12 of what's called 12 of 22 months, then you can move faster. If the child was out of care for 6 months, back in the home for 1 month, and then back into foster care, it doesn't reset that clock because you have a 12 of 22 out of foster care. And what needs to happen is we need to make sure our magistrates, as well as the judges, of course, but our children's services workers, as well as our guardian ad litems, know how to use that rule, because that's how you get that permanency for that child. And that's how one of the things that I've learned sitting on the bench already, there is about consequences. But also it's about providing positive reinforcement. When you have somebody that is doing well, we're not going to come down with that kind of, remove the child immediately and permanency automatically or permanent custody automatically. You want to do a bunch of different things and allow that person, at the treatment court, the family treatment court that was talked about earlier, our magistrate that runs that has so much energy. They were doing the treatment court out, when I was moving into the new courtroom, it was in my courtroom that they were doing it. And I'll tell you, that day was a good day for me. Why? Because you could hear them cheering each other on, trying to get through this whole process, trying to stay sober, trying to get their kids back and working hard. That's what we need more of in juvenile court, and we need to take that outside and those programs, not just in juvenile court. We need to take them outside, because once you walk in juvenile court, you already have one strike against you.
No, I agree with everything Jeff said, except I'm not sure that I would say once you walk into juvenile court, you have one strike against you. Our court is there to help a lot of families and a lot of children, so I wouldn't consider it necessarily a strike, but I agree with everything else Jeff said.
Okay, the next question then I think comes to Chad. Right. And these questions are actually, I'm going to modify them a little bit, but these are specific to the candidates based upon what you said. So you said that you have done a lot of experience you have a lot of experience as a GAL and CASA representative. Can you expound on that in terms of what your record has been in that regard as a CASA representative and as a guardian ad litem?
Well, I can share. We have to. It's not really a record. We're, the goal, and what I've strive to do every single time, is make a recommendation that's in the best interest of that child, no matter who that child is, where they come from, But the experiences that you've had, I've had because of, I don't recommend this, and I've had a child that couldn't be at his grandparents' home. Due to some reasons, CSB wouldn't place him in foster care, and for an evening, he stayed over at my house. So I know what it's like to have now a foster child in your home. Every time that wood creaked in the house, I was nervous, making sure he was doing okay. Those are those kind of things that you come up with. Another child that I had wanted me to go to his football game. And he looked up in the audience, took off his helmet, and he was looking for me. And there I was, the crazy person waving and trying to make sure that he saw me, and he still contacts me. I've had a child to come down to the law school, and him and I fought the agency because he didn't want to be adopted. But I'll tell you, I've never seen 25 law students break down as quickly as they did when he told his story about what it was like to be in foster care. So when you're absolutely representing those kids and you're making it your life, and that's what I did for 20-some plus years. And it's a great way in which to be ready to be judged, because you're already writing those decisions. You're already making those recommendations. Those are the experiences I've had. I believe it's a great qualifier for you to be judged, and I am.
I'm going to ask a follow-up if I can. Have you had any negative experiences as a GAL or as a CASA?
Yes, tell the truth.
I mean, the only reason I ask is because I have a daughter who does this in North Carolina. She's an attorney. She's a guardian ad litem. And so I know that there's great stories, the kinds you just told, but I also know there's some not. So have you ever had that experience?
Yeah, probably one of the most traumatic experiences I had with being a guardian ad litem for the child is we had a mom who basically beat the child to death, and I had to sit there at the hospital. Children's Services refused to come. I had to make the decision and work with the physicians on whether or not to determine if the child was brain dead and pull the plug. Those are the tough days.
That was illegal.
Those are the tough days, and one of the things that we have to be cautious about is that we take that time and you sit there and you know those families and you do everything right for that child as best as you can in that moment. Are there tough days? Sure. Do we, would we want to do something different and make it a little different and try and do something more positive for these kids? That's what I did all my entire time, is really to make it focused in on these kids. And that's what I continue to do. We have a kid that was just in juvenile court with me, and the sad thing is he wanted to go to the adult jail because he just wants to get used to it. So those are the things that we've got to change. I spent almost 15 more minutes with him trying to make sure that we did the right thing for him.
And Helen, I apologize. I usurped too much time, but feel free to respond.
I don't need to respond to Jeff's experience.
I didn't know whether you wanted to offer anything else on terms of your own experience. I'm sorry.
Oh, sure, I can. I believe the question is, how
Well,
do
it
you judge what kind of job you've done as a guardian ad litem? Is that fair?
Yeah, and you've also talked about the need for refresher training, and that that you may not need that because you have 2 children and the way that you feel about your children, and then also the others that you've served in a GAL. So if you could maybe expand on that, and whether or not you think that you disagree with the Rule 48 requirement for annual training for GALs.
Sure. I love the guardian ad litem training. We do have a requirement to do additional CLEs every year to stay on the guardian ad litem appointment list, and at every single training, just like every day in my life, I learn something new. Science is always coming out about children's development and trauma, especially trauma for children, and you learn so much through that training. So I agree with the Supreme Court Rule 48, and I agree with the additional training, and any day that I can learn something to help children is a good day. I believe that I've done a good job as guardian ad litem, and I would just submit that proof of that is how many times I was requested to be guardian ad litem. It got so burdensome on my own family, because you do have to see these children. You have to take it seriously. So my husband Adam can tell you, there were some weekends I never home. Evenings, never home, because those are the times you can see the children in their home environment. I went often to schools to see what was going on with that child at school and to try and help them. Because as guardian ad litem, you can do innovative things like move to put that child on an IEP. I don't know if everybody knows, but an IEP is an individualized educational plan. And a lot of these kids need them. They have needs that are not being met. So there are extraordinary measures that I regularly went to help these kids, because that's what they need. That's what I do for my own children. I was fortunate enough to learn a lot about learning differences because my son's dyslexic. So through that, I have learned so much, how to address his needs at school, and also how down on themselves a child can get in normal mainstream school if they're being told every day that they're a failure. We need to change that for our children.
So I think we're down, right? The Ohio Revised Code states that foster parents have the right to present evidence during court proceedings. How would you ensure that magistrates consistently give foster parents the opportunity to speak in court and present evidence?
Again, I will go back to policy and procedures. I think our juvenile court could have more policies and procedures, to be honest with you. Judge Capizzi has been a little short-handed. Judge Coons, who had 24 years of experience, died in May. And I'm also a new set of eyes. I have a lot of energy, but we can implement policy and procedures that we don't currently have to not only allow foster parents the opportunity to speak in court, but also to help make things more even among our magistrates. I talked earlier about the legal requirements of first extension and the fact that a first extension has to show significant progress of the parent in order to be given. The second extension has to provide substantial progress. Well, what does that mean? Let's talk about that with the magistrates so everybody's on the same page. Let's make sure the magistrates know that the foster parents have a right to speak in court. Things right now are done very differently depending on the courtroom, but we can certainly implement across the board policy and procedures.
Well, absolutely, and that's already working with Judge Capizzi, already changing some of the procedures and trying to make, that they're going to be working on changing for the consistency to have basically a magistrate in charge of each of the divisions that we have. It is important to have that consistency. In fact, that's, again, going 20 plus years in Montgomery County Juvenile Court, not only with each of the different magistrates, but children's services and even all the guardian lines, everyone has their different policies. What I've tried to do since the beginning is to make sure those policies are, we have a set policy, we then follow that procedure to make sure it happens. The easiest thing, especially in a permanent custody case, and that's what some of the important information that would be coming from the foster parents, those are going to be in front of me. So that's where they need, we'll have a consistent policy when it's in front of me. But we also need to make sure that, one of the things that we can continue to do is work with our magistrates to make sure they allow those foster parents to come in and sit in that courtroom. It's an open courtroom, they can sit in there, okay, unless they're going to testify elsewhere. But the other thing is, again, holding our guardian ad litem accountable to making sure that they're talking with the foster parents, as much as they're seeing the child. They need to be they're supposed to be going out. I want more than every 90 days to see the foster kids. And you're going to the foster home. You don't just see a child when he's at visitation with mom and dad. You do that, but you also go to their home. And then that's when you can have a great interaction with the foster family to make sure that their voice is also heard and included in our report. Our report requires that you hit all of these individuals. And if a guardian ad litem is not doing that, and the magistrate is not allowing the foster parents or their voices to be heard, clearly it needs to be changed, and that's what we're doing already in juvenile court.
No, thank you.
Okay, so this is my question. I don't know much about juvenile court, but I know a lot about judges. And both of you, you're of course already serving and you want to serve, but both of you have spent a considerable amount of time in front of judges in the juvenile court. So I guess we're starting with you, Jeff.
Yeah.
What's the one thing that you've seen in your experience from a judge that's like, that was excellent, I'm always going to do that? And what's the one thing that you've seen that it's like, that's never going to happen in my courtroom if I'm the judge?
First, the thing that I've seen it from a number of our judges, especially here in Montgomery County. I think we've been very blessed with a lot of our judges. But I will tell you, and I've already put it into practice, when you have a family or a child, a parent coming in front of you, you have to give them the time and listen to them. Failure to listen to them creates a system in which they don't have respect to the court. And I'll tell you, sitting in the courtroom and you're talking with somebody, having a conversation as to, especially with the young youth, as to why what we're doing what we are. Making sure there's positives, there can be held accountable, but making sure there's positive things. There's always, especially with our children that are coming before the court, and our parents who are struggling, they always need to hear that they've done something good. It might be something small, but we have to find that positive. The truly negative thing that would be, and again, I would never do it. I've seen it one or two judges, and clearly it doesn't work, is when they sat there and belittled somebody in front of them, whether it's an attorney, it is the parent, the child, in that case it was a criminal defendant. You know, when they come to it, and you know, what I've always said to we did a swearing in of our new employees, and I challenged them as new employees. I said, you know, one of the things that happens in our juvenile court, these families, these kids are coming in, this could be their worst day, and, you know, and we've got to help re-lift them up and build that family back together, or get that child on the positive path. And so when you belittle somebody, you lose not only that person, but you lose something in yourself.
I think the thing that I admire most is running a efficient, respectful courtroom. I think a lot of frustration from the public comes when courts aren't efficient and time lags. We've talked about temporary custody extensions, but I hear from a lot of pro se litigants, fathers wanting parenting time, that it's taking 5 months for them to get in front of the court. I don't think that's necessary. I'm not blaming our judges in juvenile court because, again, it's been a unique set of circumstances, but we can do better. We can do better. Timely access to justice is something that I have admired and plan to implement and do if I am elected judge. I think the worst thing that I see, and I see it too often in juvenile court, is parents who have children involved in abuse, neglect, or dependency cases sometimes bring those children to court. You know, they'll be 6, 10, 12 years old. That is traumatic for a child. That does not need to happen. Now, I'm not talking about when children go for an in-camera interview with a judge, because that's a totally different animal. That's just a conversation the child will have with a judge, the guardian ad litem, or the foster parents can explain to the child, hey, judge wants to check in with you. It's just going to be a conversation like you were in a park. You know, I'm not a threatening person. I know how to talk to children. But it's different when parents or any parties to a case bring children to court as a tool, a manipulative tool. I've seen children sit outside of courtrooms and cry and cry. Their hearts are breaking. It's unacceptable. Unacceptable. Again, policy and procedure that will be made clear if I become judge.
I think we've got time for one more question, and it goes to Helen. You often, and we've talked about some of these problems, but you often hear that there are elements, aspects of the child welfare system that are broken. In your opinion, is it broken? And if so, or even if not, what's the most important thing that you can do as a judge in order to try to make it better?
I think communication and a positive attitude sets the tone for making things better. Children's services workers are not bad people. They are overburdened a lot of times. Sometimes they work from 7 a.m. to 1 a.m. They have long days. They're trying to place 11 kids sometimes in one day, and they have to get those children placed. We need to try and understand each other. As foster parents, I know a lot of you are, you have your own view of things, and it's frustrating as CASAs and foster parents and children's services workers don't return your call. That's a frustrating thing. But you know what? Groups like we have here tonight, and children's services workers and groups, and the court can bring all these people together, and we can have a conversation, and we can brainstorm how to make things better. I think a lot of finger pointing goes on in our culture nowadays. It's your fault, it's your fault, it's your fault. Well, hey, it's a situation. How can we solve it? So I think as judge, you set that tone. You have an open door. You listen to the problems going on in the community, and you do your best to bring people together, to work together, not at opposite ends, but together to do the best thing for our kids.
Yeah, one of the things, one of the committees I sat on as state representative was a committee for our multi-system youth. And one of the things that have happened in our system of what needs to be fixed better is when you have a kid who's on probation, whose family's in front of an A&D, abuse, neglect, dependency magistrate, and has school issues. Okay, those are three different silos. We need to break those silos down because we need to be treating the family and the child as a whole unit. And you can do that real simple. I mean, you know, one of the things that I've done as the judge already is absolutely, you got to be collaborative. You've got to bring all the parties in, talk to everybody, ask them how to solve the problem, and actually challenge each of them. What can you do better for this child? What can you do better for this family? Really try to stay focused on what you're trying to make, making sure that the child remains at the center of that focus table. Make sure that they're the ones being acting in the best interest of the child. It is really about trying to make sure everyone is working together, moving in the right direction. Everyone has their different points of view. Everyone believes, I believe that everyone that works and that comes in front of that court, in my court, that works in juvenile court, from caseworkers to attorneys, to guardian ad litems, to the magistrates, the probation officers, they may all have different opinions, but I believe they're all doing it what they believe is in the best interest of the child. And as a judge, you need to really coordinate that and talk with everybody so that can be listened to. And especially, and again, you know, and I may have left out the foster parents, but they're an integral part of that puzzle to really help make sure that we're doing what is required for the best interest of the child.
Collaboration.
No, thank you.
So we're nearing down here to the end of the hour, and so each candidate has a 2-minute opportunity for sort of a closing statement. So Jeff, you go first.
Sure. Well, again, I want to thank everybody for coming out. Thank the law school. Thank everybody that set this up. This was a great opportunity to have to come and speak with everybody. I ask you to take, when, you know, and the voters out there and Facebook and that, I ask you to take a look at experience, my experience not only in Dayton Municipal Court as a magistrate for 3 years, my experience already on the bench, but also my whole life experience of being a servant to the community, being a guardian ad litem throughout the entire process for 20 plus years, making sure that we're acting in the best interest of the child, looking at what I did at the State House of all the different legislations that would be positive for our court. In fact, I left the State House to come back to Dayton, come back to this community to make sure. You know, the funny thing is it's better for me simply because I don't have to travel every night going back and forth, because I stayed here, lived here in Montgomery County, and practiced law in Montgomery County all those years I was there in Columbus, as well as being a great guardian ad litem for our court. In fact, the court called me multiple times to take on very difficult cases to make sure that we are doing everything that we can. So I actually take that consideration, especially for the experience, and I ask you for your vote in November.
I would also like to thank everybody for being here and all the great questions that were asked of us. I think we need to have more talks like this so that we can all understand each other better and get feedback. I really want the voters to know that I am genuine in my desire to do better, to make things better for our kids. I have no other reason to do this. I was in private practice and the seat opened up and I just knew it was the right thing for me to do. So I hope the voters feel like it's the right choice to make. I am a persistent, energetic, creative person, and I listen. And I look forward to the opportunity to work with everybody to make some serious changes in our community and help our kids. Thank you so much for your time tonight.
Well, thank you. Thanks to each of you. It's very interesting, and I think you've got a lot of information out there that people can think about. And thanks to the law school, and Andy, and everyone else involved for the opportunity to be with you. So,
And if you want more information on either of the candidates, they have data.
yeah, good luck to you.
Thank you so much.